Well, good afternoon, everyone. I'm Jim Hodges. I'm moderating the McGuire Woods and McGuire Woods Consulting discussion today on environmental policy post the 2020 elections. I serve as a partner in the McGuire Woods law firm and as also as president and CEO of McGuire Woods Consulting. With me are three of my colleagues today, and I'm going to first turn to Aaron Flynn to introduce himself, and then for the remaining colleagues to introduce themselves as well. Aaron?
Well, thank you very much, Governor. Good afternoon, everybody. It's a real pleasure to get to talk to you about these issues, especially when we're being led through the political arena by the governor. Very exciting. I'm an environmental and administrative law attorney and a partner at McGuire Woods. I actually joined the firm this year with some of my partners from Hunt & Andrews Kurth, where I had a long career there before joining McGuire Woods. And I typically advise companies and trade associations on EPA regulations, particularly regulations under the Clean Air Act. I represent them in litigation concerning those rules all over the country, primarily in the U.S. Courts of Appeals. I'm probably best known for my work on EPA's Regional Haze Program, the National Ambient Air Quality Standards, and what's called interstate transport issues or pollution that crosses state boundaries, state lines. Most recently, I've been doing a lot of work addressing ESG issues, environmental social governance reporting, and pledge-type issues, issues for the oil and gas industry, like greenhouse gas reporting requirements, and lots of concern over fracking bans, and most recently, environmental justice issues. So that's what I do on a day-to-day basis. Before I joined the private practice world, I worked as a nonpartisan energy and environmental law advisor to the members and committees of the U.S. Congress as part of the Congressional Research Service in the American Law Division there. And after that, I worked as associate counsel in the White House on science and technology issues and environmental issues, endangered species, and climate policy in particular. So that's a little bit about me. I'm excited to have this conversation with everybody today.
Thanks, Aaron. Dave Francina?
Thank you, Governor. I'm Dave Francina. I'm also a partner at McGuire Woods, and like Aaron, practice in the environmental arena. I head up McGuire Woods Environmental Law Practice Group and have been at the firm for a couple of years, having come to the firm from K&L Gates a couple of years ago. My practice is a bit more, I guess, broad-ranging than Aaron's is. It's a practice that cuts across most, pretty much an environmental generalist. So I do work on waste matters and water matters, some air matters as well. My work tends to be more sort of compliance and transactional based rather than litigation based like Aaron's is. But it really just sort of covers the waterfront, and hopefully we'll be covering some of that waterfront today. So I look forward to meeting with you all today and having a chance to discuss what the future looks like. And like Aaron, thank the governor for his time today in leading us through this discussion.
Thank you, Dave. And now, Allison Wood.
Thank you, Governor, and good afternoon, everyone. I'm Allison Wood. I am also a partner at McGuire Woods. I joined with about 7.5 months ago with Aaron, and I'm loving it here. It's a pleasure to practice with great people like Dave and the governor. My practice is environmental law. I've been doing it for over 20 years, but most of my practice focuses in the area of climate change. I have represented clients in all three of the Supreme Court cases that deal with climate regulation. I've also represented clients in the recent cases involving the Clean Power Plan, the Affordable Clean Energy Rule, and then the methane regulations for the oil and gas industry. I'm really looking forward to our discussion today, and hope you all enjoy it.
Well, thank you to my fellow team members, and just to the audience, to remind you, there is a question and answer button at the bottom where you can send your questions to us. This program is for you. It's designed for you, and we want to make sure that we answer any questions you might have. So please exercise that feature, send us questions, and as we complete the discussion, there'll be a time in which we will try to work through the questions that you might have. Let me just say a few words first about our firm before we get into our panel discussion about issues. McGuire Woods itself, we have 21 locations across the United States, 1,100 lawyers, a top-flight firm, very proud of the group that we have. We represent 8 of the top 10 Fortune 500 companies. The firm is recognized for its innovation in the practice of law. The AmLaw 50 law firm, and as you see from the list here of the areas in which we practice in the markets, we are indeed a national and international firm that have an outstanding roster of clients and, most importantly, a group of lawyers with specific expertise in a wide range of areas. I happen to also serve as a president and CEO of McGuire Woods Consulting, which is our consulting arm. It's a wholly owned subsidiary of the law firm, and we do virtually anything that touches government, both state and federal. The most unique aspect of our firm is that many consulting firms that do public affairs work either concentrate on the federal side or the state side, and we do both. And in fact have the largest state government footprint in the United States that works hand in hand with our law firm and also with our outstanding federal policy team in our Washington, D.C. office. Now I'm going to turn to Dave Ranchina to talk a little bit about our specific capabilities in the environmental practice area. Dave?
Great. Thanks, Governor. So to follow up on what the Governor says, let me start with a discussion about McGuire Woods Consulting, because one of the great benefits of being at McGuire Woods and practicing with the Governor is that the environmental group and the consulting group work hand in hand on formulating government-based solutions to environmental issues. And so it's a real one of the delights of practicing here and also one of the benefits of working with McGuire Woods. So from an environmental standpoint, McGuire Woods covers the waterfront. We have attorneys that practice in every one of the major areas: air, water, waste, chemical regulation, etc. We look at not just environmental work, but employee safety. That's obviously an issue that is growing and of importance and will be of even more importance in a future administration. Our work ranges from permitting, enforcement defense with our new colleagues in D.C., Aaron and Allison. It also includes a robust rulemaking and rulemaking defense practice as well. We're also involved with project development and, when need be, crisis management at all levels of government, because we know environmental law tends to touch all areas of government. Our practice also includes a deep bench on litigation work, and our environmental litigators are one of the strongest groups in the country, and it's also a pleasure to practice with them. Finally, I'll note that our group is not just a bunch of lawyers, guys like me who kind of came out of law school and just sort of grinding away below these many years ago, but also includes governmental regulators and lawyers with technical backgrounds. So it really helps us be a very well-rounded group and gives us the ability to advise clients on a variety of matters. So with that, why don't I turn it back over to you, Governor, so that we can begin today's program.
You got it. Thanks, Dave. I appreciate that very much, and to my fellow panelists as well for those nice introductions. Well, we're going to talk a little bit about the never-ending 2020 elections that don't seem to ever end, and the impact that we think it's going to have on policy, environmental policy moving forward. And I'm going to start with Aaron Flynn. Aaron, there always is a talk about cabinet leadership and agency leadership, and with this audience, I think one of the most significant questions is going to be about leadership at the EPA. Can you talk a little about what you're hearing and what you think regarding the Environmental Protection Agency and what might happen there?
Absolutely. And, we may not have to speculate for too much longer. I mean, just before this call started, I saw that the transition team has named 9 senior White House officials just this morning. So they're obviously moving quickly on these issues. But right now, we're still in the speculation game. So one of the names that has come up early and often, at least at the beginning of this process, was Washington Governor Jay Inslee, who was an early favorite, at least among the gossips, the political gossips out there. He ran as the climate change candidate in the Democratic presidential primary. Many of his biggest accomplishments in the state of Washington have been on climate and environmental issues. But his camp shot down the idea of Administrator Inslee pretty quickly right out of the gate. And he was just elected to a 3rd term, so I'd be surprised to see him leave the state of Washington for the city of Washington. But he could certainly play a role informally, formally now or in the future, or years down the line from now. A name that has come up early and often and has not been shot down in the press or elsewhere is Mary Nichols, the head of the California Air Resources Board. And she seems to be, if not the front runner, certainly the most talked about potential candidate for EPA administrator. She's been in charge of CARB, the California Air Resources Board, since 2007. She could be a really solid choice for a lot of different reasons. She was an assistant administrator for air and radiation at EPA during the Clinton administration, so she knows how the agency works already at a very high level. She has years of experience as the chief regulator in a very important state when it comes to environmental policy. And that's really been the model for many Democratic administrations, EPA leaders. Gina McCarthy had that type of position in Massachusetts. Lisa Jackson had that same sort of role in New Jersey. And if we go back to the Clinton years, Carol Browner ran the Florida Department of Environmental Regulation. So that's pretty good company to be in. And coming from California, and Administrator Nichols would have the sort of, cutting edge type climate experience that will matter to the administration. She's proven herself to be in line with at least Obama era policies on mobile sources and cap and trade. And she's also got the distinction of having been appointed to her current position by a Republican, Governor Schwarzenegger. So that obviously doesn't hurt. Lots of other names have come up though, either for administrator or for other high level positions. Colin O'Mara, who has Delaware ties, which doesn't hurt in the Biden administration, also has a bipartisan record. He's the current head of the National Wildlife Federation now, but that's a name that's come up a lot. His colleague, Mustafa Santiago Ali, is also at the National Wildlife Federation, former longtime EPA staffer, former assistant associate administrator. Also, he has an extensive background in environmental justice. That would be something that's probably very appealing for this administration. A couple other names, Richard Reveiz, a former dean of NYU Law School, very well-known, recognized environmental law expert. Daniel Esty, another law professor at Yale. Lots of different options, frankly. If I had to bet, I'd probably bet on Mary Nichols just because of the amount of attention she's getting, but you never know. And, the major sword of Damocles hanging over all of this is the composition of the Senate come January 20th. If it remains in Republican control, just how much compromise and negotiation on political appointees is a big question, and we'll have to wait and see how that all shakes out.
Very good points about the composition of the Senate, Aaron. And I know Jay Inslee in Washington fairly well. I would be surprised that someone who's just elected to a 3rd term as governor would want to leave at that time. It probably would be viewed as bad form. So I think you're dead on the list that you provided. Very good. So let's talk a little bit about what this all might mean. I mean, the election changes, particularly in the environmental space. Allison, I'm going to kick this over to you, but what are you hearing from a potential new administration about what their environmental priorities might be?
That's actually a very easy answer. It often isn't when a new administration comes along, but in this case, the answer is climate, climate, climate. In a very interesting development for those of us who do environmental law all the time, while it is something that is on the forefront for all of us, it's rarely that it's on the national stage as much as it is right now. When you look at the President-elect's website, his transition website, he identifies 4 major priorities that they will be looking at: COVID-19, the economic recovery, racial injustice, and the 4th is climate change. So that is, an environmental issue being placed that high in a brand new administration is unusual, and clearly it's a very high priority for them. There has also been already a lot of work done in the climate space for the transition team. If you haven't seen it, looking at a website for something that's called the Climate 21 Project is probably worth your while. You can see that at climate21, that's 21.org. And this was something that was released last week. It's a 300-page plan that environmental folks have worked on for 1.5 years that basically focuses on what the executive branch should do and what its priorities should be with regard to climate. It gives recommendations and directions for 11 different White House offices, federal departments, and agencies, broken down into what they should be doing now during the transition, what they should be doing on day 1, and then what should be done within the first 100 days. And when you look at the Climate 21 Project and the environmental priorities of the new administration, there is an undercurrent that runs through all of it, which is a theme of environmental justice. And it's already been mentioned a couple of times today, and I think it would make sense just to take a brief minute and explain, what environmental justice concerns are and, why they're important. And Aaron, would you mind doing that?
I'd be happy to. Thanks, Allison. Environmental justice issues have gotten attention for years, although I think many critics would say they've only gotten lip service, and it's really about ensuring that the burdens of pollution and negative externalities in an environmental setting don't fall disproportionately on poor communities, on minority communities, and other disadvantaged communities. That's what the crux of environmental justice is, and how to go about doing that is a difficult question that people haven't really solved, but are working on. So, right now there's an executive order that requires folks requires agencies to evaluate environmental justice issues, but it's pretty minimal, frankly. So environmental justice got a lot of attention from the Biden campaign. They had an entire plan on how to secure environmental justice that included creating an EJ division at DOJ, creating a White House office on environmental justice that's sort of equivalent to the Domestic Policy Council. And as Allison said, it's seeded throughout the Climate 21 plan that she mentioned and the transition team website. Environmental justice also, it's an obvious priority for the vice president-elect. Senator Kamala Harris is the sponsor of what I would say is probably some of the most substantial environmental justice legislation that's really ever been put out there. It sort of would create almost an environmental justice version of NEPA, where legislation and agency actions have to be evaluated for environmental justice impacts. And in fact, there are 70 pieces of environmental justice legislation pending right now before Congress, some of it really minimal, some of it much more expansive. And this is maybe one of the rare areas where there could be some sort of legislative movement. Administrator Wheeler singled out EJ issues as something that he wanted to focus on in a second Trump term. So it's possible that these issues could get traction and even have legislation move ahead. But regardless, I think there's going to be administrative action on environmental justice issues. So I would expect to see appointees inside and outside of EPA with expertise in that area and a serious push to make some substantive progress on those issues.
So for all of you, it's day one of the Biden administration, and they're sitting down to look at Trump administration policies and regs. Talk about those and which are likely to be reversed. And I'm just going to ask each of you to give me some thoughts about, on that short list of things that are going to be reversed, what they would be. Dave, you want to lead off?
Sure thing, Jim, Governor. So I'd say probably one that's from a non-air standpoint that's probably pretty clearly in the sights of the Biden administration is the closest thing we've seen in environmental law to a perpetual motion machine, which is the waters of the United States rule. I mean, this has sort of been going back and forth since the late 1980s. The Obama administration put into play a very expansive waters of the U.S. rule in 2015. It was one of the first things that the Trump administration undid when it came into office. It was very heavily litigated. Then the Trump administration, during its tenure, put into place a new waters of the U.S. rule, which was even narrower than the rule that was in place prior to the Obama administration rule. That's currently being litigated. I think it's going to be very clear that the Biden administration is going to be looking at that rule, the Trump rule, and trying to figure out how to handle it. At this point, all they're talking about is evaluating it and seeing how broad they want to expand it. It's not clear to me, at least, that would be something that will go all the way out to where the Obama administration went. And I guess one thing to look at is sort of electoral politics. Plainly, the Democrats are having a little bit of trouble in upper Midwest agricultural areas, and one of the big bones that folks had to pick with the Obama era rule was that it hit agriculture very hard. So, query whether there would be something that would be broader than the Trump rule, but not quite as broad as the Obama rule, in order to avoid hitting agriculture as hard as the Obama rule hit it. So at this point, it's a TBD, as to how far that will go. But plainly, from a water standpoint, it's one of the things that the Biden administration is going to be looking at.
Allison, what do you think? What's going to be one of the first measures that they look at reversing?
It will definitely be the Affordable Clean Energy, or ACE rule, in a real case of deja vu. And I say that because the ACE rule, the Affordable Clean Energy rule, is a rule that regulates carbon dioxide emissions from existing fossil fuel-fired power plants. And it was the replacement to a very controversial rule called the Clean Power Plan. Both of these rules are put in place under a certain provision of the Clean Air Act, Section 111D, that is a very narrow provision. And there has been a fight going on now since 2015 as to what is the scope of that provision, specifically whether you're limited to what you can do at a source itself to try to limit its carbon dioxide emissions, which there isn't a lot that you can do technologically to do that, or whether you're allowed, and this was the view of the Clean Power Plan, to go more broadly and look at the system, which was the electric grid, the connection of all the interrelated power grid, to say that we're going to dispatch lower emitting sources first. So wind and solar, nuclear, followed by gas, which is, less emitting than coal, with coal-fired generation coming last. That was very controversial. The Supreme Court issued a stay of that rule, seeming to indicate that might have been a bridge too far. The case got briefed, before the D.C. Circuit argued, and then the administration changed. The election happened right after the argument. And the case never came out by the time President Trump took office. He came into office, he signed an executive order directing EPA to reconsider that rule. The case got put in abeyance. EPA underwent a rulemaking, put in place the ACE rule. Where are we on the ACE rule? The exact same place. The rule was put in place. The case has been briefed before the D.C. Circuit. It was argued in October, and then the administration is going to change yet again. So the question will be, will this case even get decided? But I think even if it is decided, it's doubtful that a Biden EPA would defend it on any appeal. So no matter which way, the rule went, you can expect that there would be an appeal. And I would expect that, there would be an executive order similar to what happened before, directing EPA to relook at this. And so I think the big question is, what will they do in relooking at this? Will they go back to a Clean Power Plan style regulation? Or will they, as Dave was talking about, maybe not go that far, since the Supreme Court had stayed that, but what will they do in its place will be the big question.
Interesting. And Aaron, what are your thoughts about this?
Sure. Well, on the air side, outside of the climate context, I think the rules that are probably the most likely to receive the most attention, at least in the near term, are probably what are going to be some of the last major rulemakings of the Trump administration, at least from EPA. The rulemaking on once in, always in, a policy that's related to hazardous air pollutants, and the two major national ambient air quality standards setting rulemakings for particulate matter and for ozone. So talking about ozone and PM first, in both of those proceedings, EPA has proposed to retain the current air quality standards that were set back in 2015 for ozone, 2012 for PM. The final PM rule is at the Office of Management and Budget now, undergoing review. The agency has committed multiple times publicly to complete both of those rulemakings during this term. And I believe them on that. It's difficult to overstate the amount of work that goes into an NAAQS review like this. And the Trump EPA put a lot of resources into getting those rules completed within, or as close to possible as within, the actual statutory deadline for a Clean Air Act NAAQS review. So in that respect, they've done a very impressive job getting these things to the finish line. In a very short period of time. On the other hand, other folks see that as evidence of haste, evidence of a poorly thought out rulemaking process. And so these rules are definitely controversial procedurally, and because they're not proposing any tightening of the standards. So there will be pressure to certainly reopen those proceedings, maybe revisit the science, look at new science. And what the big question for me here is there an appetite to do that? Obviously, a lot can get accomplished in terms of emission reductions when you tighten the NAAQS, but it's important to think about some recent history here. The last two administrations both attempted or thought about attempting to revise or revisit or reconsider the ozone standards that had been set in the waning final days of their predecessor administrations, and both attempts failed pretty spectacularly. Either it just seemed too heavy a lift, and they just ended up deciding we're just going to move forward with the regular review proceeding as if normal. So there may be some factors here that may warrant taking a different approach this time, but I think it's really going to be a big question about competing priorities and resources for the agency. On the other hand, the once in, always in policy, I think, is probably a much more obvious candidate for some sort of reconsideration. The pre-existing policy has been around for decades, so it would not be a shock to just stick with something that's been around and has been the agency policy for a long time. I think that's a pretty obvious candidate for reconsideration.
So talk a
Governor,
little. Yeah, go ahead, Allison.
Governor, if I may, I realize there's another major regulation on the climate front that I could definitely see the Biden EPA immediately wanting to, examine and reconsider, and that's the methane standards for the oil and gas sector. They were originally put in place to regulate methane emissions from that sector by President Obama in 2016. And President Trump, as part of the same executive order that directed EPA to relook at the Clean Power Plan, had the Trump EPA also relook at these methane standards. A final rule reconsidering those, and in large part removing a lot of those regulations, was published in the Federal Register just 2 months ago in September. So it is just barely started litigation, and stays have been requested of the two rules, one of which has been denied and the other of which was just filed last Friday. So we'll have to see what the court does with those and what the new EPA does.
Hey, Allison, this is Dave. What do you think the path would be that the Biden administration would take on the methane rule? Do you think it would sort of try to go toward like rulemaking to undo the Trump administration rulemaking, or do you think that this is an important enough issue that they would try to address it by an executive order or other executive action?
It's a great question, Dave, but I think that because the new rule was put in place by a rulemaking, a notice and comment rulemaking, you can't, undo it with an executive order. It is going to require notice and comment rulemaking again to try to undo it, unless, of course, the Congressional Review Act could come into play. That's one wild card that's out there, depending on the Senate.
Can we talk about that for a minute? I know Aaron or Allison, would the CRA come into play? I mean, there's been a little bit written about that as a tool to reverse some of the policies and regs of the Trump administration. Can one of you talk about that?
Sure, I'm happy to do that. The CRA is always a subject of interest whenever there's a change in administrations, I think simply because the veto threat is presumably removed. So, and it seems on its face like a nice, neat, and tidy way to get rid of rules that don't fit with a new administration's policy objectives without having to go through what Allison was just alluding to, all the months of process that's involved in proposing to repeal a rule through the APA or Clean Air Act procedures, where you have to take comment, respond to comment, and then you've got to publish a final rule and face litigation risks related to that action. So the CRA, which allows Congress to step in, can be very appealing. It was used 14 times at the beginning of this administration, of record, never before even approaching, and one other successful use of it in its history. No EPA rules were undone at the beginning of the Trump administration, but lots of rules that had environmental policy implications. A little background on how it works. Basically, the CRA enacted as part of the Contract with America, it was a Newt Gingrich proposal. It provides for expedited legislative process to review new regulations and to reject them by passage of a joint resolution. A simple majority can do it. Once that rule's been rejected that way, the agency, the executive branch, does not have authority any longer to promulgate what's called a substantially similar rule. There are probably lots of big questions about what counts as substantially similar, but you can't go out and just redo the same rule again unless there's intervening legislation that authorizes it. So under the CRA, Congress has, what in the terms of the statute, 60 legislative days to act on that joint resolution of disapproval, 60 legislative days after the rule's published in the Federal Register. Legislative day being a day that Congress is actually in session rather than just a simple calendar day. Otherwise, the rule goes into effect, and given the makeup of the Senate, which I think is what everybody was sort of alluding to right now, even if the Democrats were to win both of the Georgia seats, using the CRA is going to be tricky unless you can keep every Democrat in the caucus on board to do that. it's going to be a heavier lift than it was at the beginning of the Trump administration. One thing that I think, on the other hand, that isn't a heavy lift that we're going to see, I think it's a virtual guarantee, is an administrative freeze. That's happened to every new administration of the modern era. So I think, day one, probably you'll see a memo from Ron Klain, the incoming chief of staff, that pauses sending any Trump administration rules to the Federal Register for publication. If there are any in the pipeline that haven't gone to the Federal Register, if there are rules that have gone to the Federal Register but haven't been published, they're going to be withdrawn from consideration for publication. And anything that was published, there'll be a directive saying postpone the effective date of that rule, either through rulemaking or whatever other measures are authorized by statute. That's going to happen.
Well, it makes plenty of sense, particularly when you look at this whole process of transition and the delays that are going to occur. It's very likely, as you pointed out, that the new administration would do that for fear that they're not going to be able to get their team in place for some time. So I think you're absolutely right. It's always happened, and in this instance, it's even more likely to happen because of that. Let me pose a question to the three of you, and you alluded to it a little bit earlier, but in terms of breaking new ground on environmental policy, what are the sort of things that you think the new administration is going to want to do in the environmental space? And Allison, why don't we start with you, and then Dave, and then Aaron? So if you would take that first.
No problem. I think the first thing that is that the Biden administration is going to have to confront. I've already talked about, the ACE rule and, how that replaced the Clean Power Plan. And I think one of the first things they're going to have to look at is whether they try to go back to a Clean Power Plan type model under 111D, or whether they determine, is 111D just too tough a row to hoe? And I say that because the litigation over this tiny provision of the Clean Air Act has now been going on for 5 years. It's very complex. Just to put it in context, the oral argument for the Clean Power Plan, which was before the en banc DC Circuit, so all the active judges on the court, there were 10 of them, went around a little more than 9 hours. That's unheard of in the DC Circuit. It's very unusual. Well, the oral argument over the ACE rule, so again, trying to use 111D Part 2, was not the en banc court, just a 3-judge panel, but again went over 9 hours. And what this tells me is that there's just too many different ways that perhaps this provision can be interpreted. And I wonder whether the administration might sit there and say, one of two things. Either we're not going to go all the way back to the Clean Power Plan model because, that got stayed by the Supreme Court the last time. The Supreme Court is only more conservative now than it was when that stay was put in. So that might not be a winning proposition for us. So then do you continue to try to use 111D, but maybe not go as far as you did in the Clean Power Plan? Or instead, do you start looking at other provisions of the Clean Air Act and thinking about whether they could be used to regulate for climate purposes? And in particular, one that's been talked about a lot is Section 115 of the Clean Air Act, the international provision, which basically allows regulation through the states. It's similar to the state implementation program to meet certain requirements to avoid endangerment to health and welfare. A lot of people have talked about the possibility of using that and possibly trying to put in place some type of, cap and trade program through it that would be much broader than just a single industry sector like the power sector, instead going more broadly. Other provisions that have been bandied about, and there are petitions for rulemaking before EPA on all of these provisions that have been there for a long time, would be the National Ambient Air Quality Standards Program, the NAAQS program, and whether, GHGs, greenhouse gases, should be listed as a NAAQS. There are a lot of problems with that approach too. None of these approaches is perfect, and that's part of the problem here, is that despite the Supreme Court's ruling in 2007 in the case Massachusetts versus EPA that said that EPA could regulate greenhouse gases through the Clean Air Act, the act really truly wasn't intended for climate purposes, and so it's a lot of square pegs and round holes, and nothing is very works very well. But we know that climate, I talked about this, is one of the biggest priorities of this administration. And if you can't do legislation, then you're going to have to try to work through this administrative process, and the Clean Air Act is the best vehicle to do that. So what I expect is that they will try possibly new provisions of the Act in addition to the ones they've been trying.
Dave?
So, you know, when you kind of pull apart what the Biden administration is focusing on, it is, you can scroll a long way through policy statements before you find something that deals with something other than climate or air or environmental justice, right? And so I've been kind of think about like what might be something that would fall into one of those buckets that the environmental community has been looking at, but there hasn't really been much action on in recent years, and that would be ripe for something like the Biden administration to pick up. And one that I sort of wonder about is the area of emerging contaminants, right? There are these, sort of contaminants that we don't know a lot about, but that are ubiquitous in the environment. And I'll pick out one of them, 1,4-dioxane, which is sort of used as a stabilizer, but shows up in things like soaps, right? And it's one of those, contaminants that has sort of drawn a lot of attention from the federal government and from the states. And the federal government has been looking at it, but has been developing standards, but really hasn't gotten all the way there on the standards. The states, have not been very happy with the speed with which the federal government's been handling this. And so a lot of states have been putting together their own programs and generating their own numbers. And some of those numbers are very, very strict and have sort of come up with their own paths of when they evaluate for these chemicals. And it's led to a bit of a patchwork. And so one thing that I just sort of throw out there, not knowing, but just sort of a gut sense is, whether the Biden administration is going to want to exercise some leadership in this area and start, either regulating the chemicals we know about or come up with a structure to continue to evaluate new chemicals as they come up, because one thing that we're seeing is there's a lot about chemicals that are being used that we might not know as much about as we'd like, or whether they want to back off and let the states handle this. My guess is that there probably will be some leadership, but the federal government is going to be reluctant to get in the way of states that have regulated this more stringently, particularly because a lot of those states are places where the president-elect has got a lot of political support. So to me, emerging contaminants might be one of those places where we get more activity out of the Biden administration than we anticipate, and that aren't directly related to, climate, air, or environmental justice.
Aaron, what are your thoughts?
Yeah, well, I think at the beginning of the Trump administration, the administrator at the time, Scott Pruitt, announced what he called his back to basics approach to regulation, and that got carried through throughout the rest of the term. And I think you can kind of sum that philosophy up as a focus on cooperative federalism, devolving as many decisions to the states as you can, and having EPA focus on fundamentals like meeting statutory deadlines and following through on basic regulatory commands that are direct in the Clean Air Act rather than going off and looking for ways to create new regulatory programs. I think with this administration, we're gonna see a flip back, a return to form to at least with respect to, traditional air pollutants, to what the Obama EPA was doing on many of those issues. So, for example, I think some programs that looked like maybe might have eased up under a Trump EPA will see a stronger hand from Washington. And I'll take regional haze as an example. That program was really, really leveraged during the Obama years to exact what I think is fair to characterize as stringent emission control concessions from industry, mostly power plants, but not exclusively, in ways that I think folks who, companies, industry, and states who began implementing that program during the George W. Bush years just did not foresee happening. There were a record number of state implementation plans under that program that were rejected and replaced with federal implementation plans, so the EPA taking control over things that are typically done by the states. And we're really just starting in earnest to implement that program again it's what's called its second planning period. And there were some hints that the Trump administration perhaps was going to allow states more leeway during the second planning period than they got during the first planning period. And there were hints that the Trump EPA didn't necessarily think that states were going to have to do all that much for the second planning period, that they could defer more aggressive action to the next 10-year planning period, not just from political appointees, even from staff that I had spoken to. And that may remain the case, but I doubt it. If you look at the difference between the Trump administration guidance on how to implement the regional haze program and the draft guidance that came out from the Obama administration that never got finalized, I think you've got a clear roadmap to a much stronger form of implementation of existing programs, looking to find ways to get as much emission reduction as possible from as many different types of industry as possible in a new Biden EPA. And I think you're also, in addition to that, going to see a big increase in terms of enforcement. And I don't just mean an uptick in cases attempting to actually resolve individual violations, but also the use of strong enforcement initiatives to effectively set new policy, which is something that happens regularly in our system of government, happens at EPA a lot. And it was used quite a bit in the Obama administration to get major emission reductions. It's especially appealing when you aren't ready to start undertaking major rulemaking actions, when you don't have the people in place to do it, and when you haven't had the time to develop them. You can move much more nimbly with enforcement. And during the Obama years, we saw lots of industries, oil and gas in particular, became subject of enforcement initiatives before they became the heavy focus of rulemaking proceedings. And I think we'll see that again, especially for the industries that I kind of think of as the leftovers, the folks who haven't had the glare of rulemaking on them to date. And there are a lot of those. They're called out in the Climate 21 plan for climate, and I think we'll see it happen for traditional pollution as well.
So we have a little over 10 minutes left in our discussion. We have a lot of ground to cover, but one area I did want to talk a little bit about is this whole idea during the Trump years of streamlining the environmental regulation processes to make them less burdensome on business. What do you think is going to happen with that? I mean, what will the Biden administration do with those activities? Dave, why don't you start?
Sure thing, Governor. So, and I value the thoughts of my colleagues on this, because one of the signature achievements of the Trump administration was to sort of get NEPA, the National Environmental Policy Act, which sort of, evaluates sort of in a broad sense large projects where there's a need for federal input, either because it's statutorily required or because of expenditures. Sort of back in the day, it wasn't uncommon for NEPA review to take, 5, 7, 10 or more years, right? And so that ended up being a significant stumbling block on a number of projects, particularly sort of large infrastructure projects. Pipelines are a good example of that. We've all sort of seen, the Dakota XL pipeline and how slow that's been to move along, in part because of NEPA. And one thing the Trump administration did was to say for most activities that are regulated by NEPA, sort of the short process of doing an environmental assessment should take 1 year, and the more involved process of doing an environmental impact should take 2 years, which is sort of a dramatic shortening of what what was sort of formerly the case. And there were other streamlining activities that went along with that as well, but the thing that I sort of wonder about is, with the Biden administration, whether they're not going to view that shortening as being something that would enhance materially the Biden administration's focus on doing really significant infrastructure projects, right? We've all read about, transportation infrastructure projects like new rail projects and improving the grid and enhancing renewable energy. All those are and there are others, right, are significant projects, many of which will have to go through the NEPA process, and one could easily envision the Biden administration looking to take the benefit of the Trump streamlining and pocket that as something that allows them to move forward, even as they continue to use NEPA as a hammer for less projects that are less consistent with Biden administration sensibilities, like pipeline construction. So to me, that NEPA streamlining is something where I think you might see the Biden administration not push back so hard on the Trump administration efforts, because the benefit would have for infrastructure development.
Aaron, what are your thoughts?
Yeah, I think Dave raises a really interesting point, which is, there's sort of a double-edged sword here in terms of the benefits of streamlining versus the principles that are upheld by not having more streamlined procedures. And when I'm thinking about the NAAQS process, the NAAQS standard setting process, which, as I think I alluded to, typically takes more than 5 years to get through that, even though the statute says do it in 5 years. And to make that a possibility, to do it in, frankly, less than 5 years, given how much time the administration had, they had to cut out a lot of, long-standing traditional steps that have been in place for at least a decade, modified here and there, in order to make that process doable. So they had a science assessment document. They cut the risk and exposure assessment document for the ozone and PM and merged it into the policy document, just did one draft of each rather than multiple drafts, one round of public comment on all of those, one round of science advisor comments on all of those rather than multiple rounds of it, cut back the number of scientific consultants, panels, expert panels that reviewed the documents. All of that was hugely controversial. From the environmental group standpoint, from some science community standpoint, people were highly opposed to those actions and were demanding major changes. So there'll be a lot of pressure to go back to the Obama approach, the George W. Bush approach, even to how those reviews are conducted. On the other hand, this is the first time that those reviews have been completed in anything approximating what the statute requires, and there's a lot of appeal in getting your own standards promulgated as quickly as possible. So there's going to be some competing interests there in terms of how these get done. I think we'll probably see a return to the old form, though, at least on NAAQS.
So I'm going to let Allison also share her thoughts, and then we have 4 or 5 questions. And I thought, group, we would, after Allison responds, we'll turn to our questions to close things out. So, Allison?
Governor, I would like to actually turn the tables just for a second, and then we'll go to the questions and answers. And I would like to turn the tables and ask you a question, if you don't mind.
Sure.
I'm taking over your moderator role.
That's all right.
I'd like to hear from you. We've been talking so much about the regulatory side. I'd really like to hear from you. What do you think the chances are for federal legislation on environmental issues. Is there any chance?
Well, I think the chances are fairly remote. I mean, best case scenario for Biden is a 50-50 Senate. He certainly has the House, and clearly they can pass legislation in the House. But even if the Democrats were to pick up the 2 seats in the Senate in Georgia, the ability to hold all of their members on environmental issues. I mean, Joe Manchin has a certain point of view about some environmental issues. John Tester from Montana. I think the issue is that Biden is not going to have as strong a Senate as he expected to have the day before the election. Best case scenario, he has a narrow path to pass legislation. So I tend to think that it's more likely, Allison, that you'll see executive orders, regs. You'll see the other tools in the toolbox utilized, because I think the chances of getting anything with any large measure of controversy passed are fairly remote. And it's the map gets a little more favorable in 2 years in terms of the races that are up in the Senate. There's a flip side of that, and the flip side is, while the map gets a little better for Democrats, the history at midterms for first-term presidents is generally not all that great in terms of their party hanging on or expanding their seats. So those are the challenges that they face. But I think, by and large, that the legislative activity may be more about show, and that the real efforts will be around executive orders and other regulatory policy as tools that they might use. So that's my thought about what's going to happen. So why don't we do this? Why don't we turn to questions? I want to make sure we answer those that we have, and some of these we've partially covered. But the first question that we had was, what impact does the panel expect to see on the waters of the U.S. situation with regard to what is currently in place? And I think, Dave, you talked a bit about this earlier. Anything to add to our initial discussion?
I would say the only other thing to add on waters of the U.S., because it's definitely going to be looking backward to some extent, is an early tell is going to be, whether and to what extent the Biden administration, what they do with the outstanding litigation, right? Because there's litigation defending the Trump rule, right? And so, if they just drop that defense of the Trump rule, which makes sense, that's going to be an early sign that they're intending to sort of undo the Trump WOTUS rule and go with a new WOTUS water of the U.S. rulemaking, status to be determined, or how broad it's going to be. So I think it's direction on that.
Okay. Another question we had was about the Supreme Court. Given the Supreme Court's extreme action to stay the CPP, would you expect the Biden administration to attempt this interpretation of CAA Section 111D? Who wants to take that?
That would be me, Governor. And I did touch on this when I was talking about 111D. I think it really is going to come down to resources. If you have a lot of resources, you could take another stab, I suppose, at a Clean Power Plan type rule, recognizing that there's a chance that, as the questioner notes, the Supreme Court's become only more conservative. So if the earlier Supreme Court stated, the odds that you can get it through the Supreme Court, don't look good for you. On the other hand, you don't necessarily want to, that no court has to date, really ruled on the issue, so you never know what could happen. And I say it's a resource question because why I say that is, if I were in the Biden administration, I might try again on a CPP type thing under 111D, or perhaps narrow my interpretation of it a little. But I would also probably, if I had the resources, try to pursue some other parallel paths so that if the CPP, new CPP type rule failed, I had other things in the pipeline. And those are those other provisions of the Clean Air Act that I was talking about. Maybe try some of those as well.
Okay. thanks very much with that. And I'm going to try to cover these last two. We're about to the end of our time, but we can stay over for a minute. Next question was, could you comment on what you predict will happen with the nationwide permit program that the Army Corps published for public comment, with staff saying they will publish the final version prior to the next administration? Anyone in the group want to comment on that?
Yeah, Governor is probably best in my corner. So that the nationwide permit rule is a rule that sets out wetland permits by rule, right? So it's a series of 40, 45 permits that allow for wetland disturbing activities and water disturbing activities. They need to come up for renewal every 5 years, and the questioner is right. These just were published the other day. I've got to think, and if you take a look at the other headlines, that the Trump administration is doing what a lot of administrations do in their last days, which is to push as many rules that reflect their priorities over the line as possible before the end of the administration. And so I can easily see those becoming final, and then the question would be, would they be subject to litigation for one reason or another? But I could easily see those becoming final because, the Trump administration views those things as things that kind of, get in the way of development, and the Biden administration kind of views them the opposite way, right? Its goals are to sort of set aside land and set aside waters and leave those preserved, which is sort of the opposite of what wetlands, development of wetlands is all about.
Well, and a follow-up question that came in from the same questioner, predictions on who will be nominated for the Assistant Secretary of the Civil Works position of the Army, who will be on point for Waters of the U.S. changes, et cetera. Any thoughts about that? Anyone have any ideas, or are you hearing any names? Probably our D.C. group.
I haven't heard any names on that yet. I think the early gossip is all at the very top level so far. I expect once those top names get put in place, then we'll start to, it'll start to trickle down, because they'll want to have the input of that top person into who their deputies are going to be.
I agree with Allison.
And I'm not aware of names either, but I think it's kind of fair to view that as being someone who's likely to sort of follow along the Biden administration's goal of more preservation of waters, right? And so it's going to be someone who probably shares those views as being the person who's designated for that role.
And just, I think, a reminder that we talked about this earlier, the longer the transition is delayed, the more difficult it makes to fill these positions on a timely basis. So, I mean, that's clearly they're looking to fill the top level positions, and there are no shortage of, looking at my inbox, there are no shortage of candidates for various jobs in the administration, but it's not going to be a situation where they are quickly moving in January to fill all these second and third tier jobs in the administration, as important as they are, because this transition will be a little more difficult than some others have been. Final question, and this is, what actions do you anticipate that will help solar? Tariff reduction, ITC extension, FERC commission changes, any others? Who wants to take a bite at that? Anyone?
This is Aaron. I'll give a stab and see what others have to say. For a long time during previous elections, there was always a reference to, I support an all of the above energy policy, which was, a quick reference to I support natural gas, coal, and renewables. I think all of the above now is going to be anything and everything you can do to support renewables and to reduce greenhouse gas emissions. That's going to be the new definition of all of the above. And if you take a look at the Climate 21 project plan that Allison talked about, you can see, at least at 11 different federal agencies, what type of recommendations folks that are very much a part of the transition team, very much keyed into the transition team, are recommending. And they're talking about all of those exact same things. So if you look at the Treasury report from Climate 21, you will see that ITC tax credit extension in there, absolutely. You'll see there isn't a FERC report, but there's a Department of Energy report, and I think there's reference in there to carbon pricing and using a carbon price to support the competitiveness of renewables. And there's a Department of the Interior report. So if you look at that, you'll see that there's all sorts of recommendations for supporting permitting of renewables, including solar, on federal public lands. So if you want to get a universe of different types of options of things that could be used to support solar, I'd strongly recommend, probably don't want a reading assignment, but I'd recommend going and looking at the Climate 21 reports and thinking broadly. There's going to be a major push to implement this across the federal government using every agency in the executive branch that can have some positive bearing on it.
Aaron, thanks for giving us all some nighttime reading that will help us go to sleep. With that, we're just a few minutes over, but I want to thank the panelists here, Aaron Flynn, Dave Franchina, Allison Wood, for just an outstanding job of covering the landscape of environmental issues, and it's all just beginning with the new administration coming in. To our audience, we had well over 150 people sign up to be with us today and had an outstanding crowd. Let me just remind you that you will be sent a link which will include the presentation that was made today. Please, if you have any questions, contact any of us. Our emails and phone numbers are there. For any issues that weren't covered, or if you had questions that you were not able to ask, please feel free to do that. And we also would encourage you, if you feel this program could be beneficial to any of your work colleagues or others, feel free to share it, because the link will allow them to explore the issues that we discussed today. With that, on behalf of McGuire Woods Law Firm and McGuire Woods Consulting, we thank you for being with us. And again, great appreciation to the panel who joined us today.